viewers. I am Dr. Premchand from National Law University, Delhi. It is my pleasure to welcome you to this session on a not so common topic in the law of property, that is mortgage by conditional sale. In this session, we would learn about the meaning and significance of the mortgage by conditional sale. This session would help the viewers understand the importance of the concept and will be able to make out the situations in which the doctrine would be attracted, and will be able to understand the effect of such an application. A mortgage by conditional sale. A mortgage by conditional sale, a mortgager ostensibly sells the mortgage property, but on the condition that on the default of repayment of the mortgage money by a certain date, the sale will become absolute. On the payment being made, the sale will also become void, and on the payment being made, the buyer will have to transfer the property back to the seller. Section 58C of the Transfer of Property Act 1882 defines a mortgage by conditional sale. It is defined as an ostensible sale on the condition that on repayment the buyer will transfer the property back to the seller. The mortgagor states in the deed that he sells the property for the mortgage money as a consideration subject to conditions. And so, a mortgage by conditional sale is where the mortgagor sells the property to the mortgagee on the certain conditions that in event of default of the repayment of the mortgage money, the sale will become absolute, and on the repayment of the money, the sale will also become void, and the mortgagee will have to transfer the property back to the mortgagor. While a title deed is a legal document which is used to prove ownership of a piece of property, mostly title deeds are used as evidence of ownership for homes and vehicles, although technically a deed of title could also be issued for another form of the property. A title deed confers upon certain rights and privileges on the person who holds it, and such deeds are necessary in situations where people wants to transfer ownership of their property. Essential features of a mortgage by conditional sale. When the mortgagor fails to repay the mortgage money by a certain date, the sale becomes absolute. Number 2, if the mortgagors repay the mortgage money by a certain period or date, the sale becomes void and the mortgagor becomes the owner of the mortgage property. Number 3, the transaction also resembles that of sale, though it is only a mortgage. The ostensible sale becomes an absolute sale if only the mortgagor fails to repay the debts by the specified date or period of time. This can be enforced through proceedings for foreclosure of the mortgage. The order of foreclosure by a court converts the mortgage by conditional sale into an absolute sale. Essentials of mortgage and conditional sale. In case of a simple mortgage, without delivering possession of the mortgage property, a mortgagor bind himself personally to pay the mortgage money. He agrees expressly or impliedly that in the event of his failing to pay according to his contract, the mortgagee will have a right to sell the mortgage property, and the proceeds of sale go towards the mortgage money. This transaction is called a simple mortgage. A mortgage by conditional sale is different. In case of a mortgage by conditional sale, a mortgagor ostensibly sells the mortgage property on the condition that on default of repayment of the mortgage money by a certain date, the sale will become absolute. On the payment being made, the sale will become void, and On the payment being made, the buyer will have to transfer the property back to the seller. Section 58C of the Transfer of Property Act defines a mortgage by conditional sale. It is defined as an ostensible sale on the condition that on repayment the buyer will transfer property back to the seller. The mortgagor states in the deed that he sells the property for mortgage money as a consideration subject to conditions. So, a mortgage by conditional sale is when the mortgagor sells the property to the mortgagee on such condition that in event of default of repayment of mortgage money, the sale will become absolute, and on the repayment of money, the sale becomes void, and the mortgagee will have to transfer the property back to the mortgagor. Mortgage is a term most of us are familiar with, even if we aren't aware of its legal definition. The widely held views about mortgage corresponds to what is termed in the language of the law as simple mortgage. However, mortgage as a transaction is not restricted to only the simple type as presumed by the layman. The ambit of transactions covered under mortgage is very wide and includes, among others, usufructuary mortgages, anomalous mortgages, and mortgage by conditional sale, which is the topic that shall be dealt with this module. Before we deal with a particular type of mortgage, it is essential to understand how mortgage is generally defined by the black letter of the law. In the case of Gopal versus Parsutam, 1883, Justice Mahmood said that mortgage as understood in this country cannot be defined better than by the definition adopted by the legislature in section 58 of the Transfer of Property Act. It therefore makes immense sense to examine the said section of the given act, which holds that mortgage is the transfer of an interest in specific immovable property for the purpose of securing the payment of money advanced or to be advanced by way of loan, an existing or future debt, or the performance of an engagement which may give rise to a pecuniary liability. The self-explanatory of the section is evident from its language that the way it has been worded serves to cover a myriad of scenarios. One of the scenarios covered under this section and dealt with under a subsequent clause of the same section is that of a mortgage by conditional sale, clause C of section 58 of the Act of Transfer of Property. It provides that where the mortgagor ostensibly sells the mortgage property on condition that on default of payment of the mortgage money on a certain date the sale shall become absolute, or on condition that on such payment being made the sale shall become void, or on condition that on such payment being made the buyer shall transfer the property to the seller. The transaction is called a mortgage by conditional sale. The Privy Council has said that it can be assumed that the intention of the framers of the Transfer of Property Act was to provide legal validity to pre-existing customs and practices by framing the laws so as to include mortgage by conditional sale as a specific type of mortgage. Mortgages by sale were referred to by a multitude of names in the various parts of Indian subcontinent, from Kachakbala in Bengal and Gehen Lehen in Bombay, Mudatta Kariyam or Perutham in Madras. Among the followers of Islam, such transactions were denoted by phrase by bil wafa and were used as an evasive device against the Islamic prohibitions of interest. Mortgage by conditional sale allows the mortgagee to become the absolute owner of the property in the event of the mortgagor defaulting on the debt repayment. Sir Padma Charan Banerjee's opinion on the law of mortgage in the reported case of Bal Kishan versus Leg was an example of lucid exposition of the law on mortgage by conditional sale, commonly known as Bai Bil Wafa in this state. The Privy Council upheld the decision on appeal, his judgment on various aspects of property law in general and this aspect of mortgage, that is, mortgage by conditional transfer in specific, is followed by courts and councils alike throughout the country. Difference between sale and mortgage, as mentioned in the previous section, intention plays an enormous role in the determination of the nature of the transaction between the ostensible buyer and the seller of the property. However, certain extrinsic circumstantial evidence can also be immensely helpful and relevant in the above mentioned determination. Outstanding debt or the lack thereof is an example of such evidence. If there exists such a relationship between the parties where one is indebted to the other, it creates an impression in favor of mortgage rather than sale. The absence of debt excludes the possibility of mortgage even though the presence is necessary but not sufficient condition to prove mortgage. The price paid for repurchase of the property shall indicate whether the transaction is a mortgage or not. If the repurchase happens at the price of sale but with interest, or if the price is below the normal market value of the property, assumption of mortgage will be favored over that of sale. If the possession of the property stays with the ostensible seller even after the sale deed, it can be taken to be a mortgage rather than a sale. Also, if the time for reconveyance of property is longer, evidence favors mortgage. What are the advantages of mortgage by conditional sale? There are various advantages with this kind of mortgage. In the case of simple mortgage, if there is any default in the repayment of money, the property has to be brought to sale for recovery of the debts, and there arises no question of the mortgagee becoming an absolute owner of the same property. The mortgagee has to be resorted to lengthy legal steps. However, in the case of mortgage by conditional sale, the mortgagor here becomes a legal owner absolutely when a default in payment occurs on the specified due date or time. Ostensible sale in the case of mortgage by conditional sale is in reality a mortgage which is the subject to the conditions set out in the said document. A mortgagee also cannot claim for a right of ownership on the date of the execution of the mortgage by conditional sale. It happens only if and when the conditions which is embodied in the said document are not complied with by the mortgagor, that the mortgagee can lay claims to the ownership of the same mortgage property ostensibly sold under the said document. Till then, the property would continue to remain the property of the mortgagor. The right of the redemption of the mortgage vests with the mortgagor, and the mortgagee will remain under the obligation or duty to discharge the mortgage on the same conditions that are embodied in the document regarding payment within the stipulated time date being fulfilled. It is to be noted that mortgage by conditional sale is a mortgage and not a sale. It is also liable to be cancelled at the option of the mortgagor at a subsequent date or time. A mortgage, once created, remains a mortgage unless it is foreclosed or redeemed. amendment of section 58C, if the condition of retransfer is embodied in the document effecting the ostensible sale, then such transfer is not regarded as a mortgage by conditional sale. This is useful to know the mortgage by conditional sale, legal and judicial position of mortgage by conditional sale. Certain characteristics need to be present in a transaction for it to be classified as a mortgage by conditional sale. First, as the name itself suggests, there needs to be a sale. An ostensible sale is necessary for such type of mortgage. Second, as also evidenced by the name itself, the need for a condition accompanying the sale insofar as this particular class of transactions is concerned, the condition required is fairly simple. The ostensible sale shall get converted to an absolute sale if the mortgagor is unable to repay the debt by specified date. McLean, Chief Justice, recognized the importance of the date of repayment of debt by the mortgagor to the mortgagee. He held that this certain date is an essential element of the mortgage in a Calcutta High Court case of Kinuram versus Nitwechand of 1907. The phrase on a certain date was expanded to include dates on or before the specified date in a subsequent judgment of the same court. Madras High Court, in a case then held that the phrase was inapplicable to mortgages dealt with under clause C of the section 58 of the Act and hence were not relevant to mortgages by conditional sale as prior judgments of the Calcutta High Court had held to be, and in this view the phrase was reiterated by the Gujarat High Court in a subsequent case. Personal liability has not been dealt with the definition of mortgages carried out through conditional sales and has been declared not to be a crucial ingredient of the transaction in the landmark case of Balkishan versus Lag 1897. Every conditional sale does not in itself imply a mortgage by conditional sale, and the intention of the parties as to their rights and liabilities during the ostensible sale plays an extremely important part in the determination of the nature of the contract entered into by the parties. Clause C of section 58 of Transfer of Property Act of 1882, that is the part of the act relevant to the transactions amounting to mortgages by conditional transfer, has not always been the same. The one major change undergone by this part was in 1929, when a proviso was added to the clause. Prior to the inclusion of this proviso in this act, the relevant transactions involved were carried out through two documents. The same deed was one of the documents, the other being one conveying the condition of reconveyance. The question raised with respect to the condition type of document was whether it converted the sale transaction to one of mortgage or simply gave the mortgagor or vendor, as the case may be, the right to repurchase the property. As already mentioned, intention of the parties is crucial for the determination of the nature of transaction. Generally, courts assuming the ostensible buyer of the land to be in a position of the power over the ostensible seller favor the possibility of the transaction being a mortgage instead of a sale. In transactions which were in the form of absolute transfers but are being claimed to be mere mortgages, evidence can be admitted before the court notwithstanding anything contained in section 92 of Indian Evidence Act. It has been noticed that Muslims have tried to misuse these buy bill wafa transactions to claim as absolute sale. transactions, which are merely mortgages of the conditional sale type, and that the mere absence of the date on which money needs to be repaid does not establish the lack of mortgage altogether. In the case of Prag Dutt versus Harish Bahadur 1947, it was held that two documents were evidence of one transaction, and that transaction was not that of a sale but of mortgage by conditional sale. Section 19 of Transfer of Property Amendment Act of 1929 enabled the addition of the proviso to clause C of section 58 of the Act, provided that no such transaction shall be deemed to be a mortgage unless the condition is embodied in the document, which effects or purports to affect the sale. After this proviso came into effect, the deed purporting to effect sale would be classified as a mortgage by conditional sale if it fulfilled any of the three conditions given under clause C of section 58 of the Act, the language of which is reproduced here, where the mortgagor ostensibly sells the mortgage property on condition that on default of payment of mortgage money on a certain date, the sale shall become absolute, or on condition that on such payment being made, the sale shall become void, or on condition that on such payment being made, the buyer shall transfer the property to the seller. The transaction is called a mortgage by conditional sale, and the mortgagee is a mortgagee by conditional sale. These conditions for judging whether given circumstance is a sale or mortgage were applied in the case of Devi Singh versus Jagdish Saran of 1952. However, this amendment is not retrospective. Also, now for transaction to be treated as a mortgage by conditional sale and not sale itself, it is imperative that the condition for repurchases needs to be necessarily incorporated into the same document and that provides for the ostensible sale. This is in stark contrast to the functioning of this law prior to the amendment, given the decrease in the number of documents and the great emphasis now placed on the inclusion of the repurchases clause in the original sale deed itself. However, it does not in any way claim that all such documents containing the repurchase clause within them would amongst the mortgages. Intention of the parties was and remains paramount, and evidence can be produced before the courts to support one's claims in case they are in contrast to the written word of the deed in question. In conclusion, mortgage by conditional sale is a type of mortgage where there occurs an ostensible sale which is converted into absolute sale in the event that the ostensible seller is unable to repay the loan. The ostensible seller in such a mortgage incurs no personal liability as far as debt is concerned. Previously, the relevant sections of law pertaining to this topic was framed so as to ensure that two separate documents were drawn up to carry out such a transaction, the sale deed and another document regarding the reconveyance of the property. This is all for today. Thanks for watching.